Hey folks, this is immigration attorney Hassan Abdullah here in the San Francisco Bay Area, and I'm preparing this video to discuss the topic of denials of I-751 cases and denials of marriage petitions. So, what happens if you applied for a green card through marriage? You are in the United States, you apply for adjustment of status, and you go to the interview, and then the officer determines that the marriage is not bona fide because of inconsistencies in the answers, and they just say, this is not a genuine marriage, and I deny the case. Or you have the similar experience by filing an I-751, and that I-751 is denied. What do you do now? Well, people sometimes feel that that's the end of the line and get ready to go to immigration court, go into removal proceedings, and you're going to be deported. That's not necessarily true. You have options, and I want to discuss, I want to explain that the options are pretty similar in both situations. If you have an I-130 and it's denied, based on them finding that the marriage is not genuine, you may have had an officer who's not viewing the situation honestly, and they were trying to just twist things to make you deny the genuineness of the marriage or try to create inconsistencies by using tactics to confuse you. It happens sometimes, particularly when, not to scare anybody, but particularly it can happen when an attorney is not there. And if an attorney is there to witness the interview and keep notes and keep track of it, surely the officer will be less likely to attempt these things, especially if someone can interrupt and say that these are not reasonable questions and so on. Now, and obviously you'll have a note taker at the interview if you have an attorney attend the interview with you. It's useful to have an attorney, definitely, in marriage interviews or cancellation of removal of conditions. Now, anyway, often what happens if you are not successful in your interview, they might say, we're going to refer this to ICE and put you into removal proceedings, but sometimes they take a long time and ICE doesn't do anything. You just sit around doing nothing and just waiting for something without having legal status in the United States. You can just go ahead and refile the case and have another chance to plead and prove your case. It's not out of the ordinary to refile a case and try it again, okay? And then add more evidence to support the bona fides of the marriage. Sometimes what happens in these interviews is they really intimidate people. And I've also known of examples where one of the spouses might have sort of a mental condition that may have not been diagnosed or explained in the application, and the officer basically turns it into an interrogation, and the person who's doing the interview might not answer questions accurately, might panic, might be afraid, might be intimidated and threatened, and might even sign statements under coercion because they're not in their proper mental faculties. These things happen. Sometimes someone might actually have a mental condition, like I said, and they might even say things that are not true under that pressure. And in that situation, we do recommend to refile the case, add some additional evidence showing that the marriage is bona fide, add some additional evidence that you have these issues and that you'd like them to be taken into consideration. And even if you have been referred to immigration court, there may be options, there may be still an option to refile the case and have a stay on the proceedings, request the court to extend your hearing to a future date, and if you get your I-130 approved, do an adjustment of status, and then administratively close the proceedings. There's different possibilities. Another thing is, if you file a 751, there's a specific USCIS memo that says, and as of the recording of this video, maybe things can change in the future. So, but as of the recording of this video, the policy is that if you file an I-751 and it's denied, you are perfectly within your right to refile an I-751 if there's additional evidence. Now, I know it's scary because you'll see on the I-751 it will say that, you know, you no longer have your permanent resident status, you're going to be referred to immigration court, something like that. You can still apply for removal of conditions, but you have to distinguish your new petition, your new application to remove conditions from your previous application. So you have to add some additional evidence that, you know, you didn't have ready, and add some more argument to it, and you're within your right to file another 751 to remove conditions, claiming that you had a bona fide marriage. And even if court proceedings are pending, if USCIS is still holding jurisdiction, and they do continue to hold jurisdiction as long as you file a non-frivolous case with additional documents, additional evidence, you have no problem. You shouldn't have a problem, that is, according to the current USCIS policy on the issue of holding jurisdiction. So there's ways around this, there's ways to fight, and that's basically the purpose of this video. It's a little bit shorter than some of my other videos, but I just wanted to help give some hope to people who may have had some of the most terrible news in their life, which would be a denial on their spouse petition or a denial on their removal of conditions. There are possibilities, there are ways to just fight this again and make your case stronger in a subsequent filing. So thank you for watching this video. I hope you found it helpful, and bye for now.